is our leader of the House, Malas, that letter is written by the Speaker, Malas. For example, Malas, recently, when Malas, Mr. Kharge became the whip, became the leader of the Congress party, it is Mrs. Gandhi who wrote a letter saying that now, instead of Ghulam Nabi Azad, Mr. Kharge is the leader of the party. I have the letter with me. So this is the, on what basis did the Speaker do it? The aforesaid communication of the Speaker of 3rd July was challenged by Sunil Prabhu before this Honorable Court, wherein the Honorable Court, by order dated 4/7 in writ petition, directed to list the writ petition along with other connected writ petitions. So that's also pending. Then 4/7, as the Speaker has misconducted himself by entering into the political thicket and attempted to recognize Bharat Gogavle as the Chief Whip of the Shivsena, certain MLAs submitted a notice to the Principal Secretary, Maharashtra Legislative Assembly, to move a resolution for removal of Navekar from the office. Then, on 4/7, the confidence motion was called for on the floor of the Maharashtra Legislative Assembly by Eknath Shinde on 4th of July. Confidence motion was carried out in favor of Eknath Shinde. Again, several MLAs of the Shiv Sena voted contrary to the whip issued by the official Chief Whip of the Shiv Sena. 4/7/2022, Bharat Gogavle, and when your lordships will see the petition before the Election Commission, till the 18th of July, there is no reference to any meeting of any political party. So all this was happening outside the political party. Bharat Gogavle also filed disqualification petitions against 14 MLAs under the 10th schedule for the alleged breach of the whip issued by him. It is submitted that Bharat Gogavle has not been authorized by Shiv Sena political party to issue whips on behalf of the Shiv Sena. 5/7/2022, since the delinquent MLAs of the SSLP has openly defied the whip dated 2/7/2022 in the floor test, confidence motion held on 4/7, Sunil Prabhu has filed fresh disqualification petitions against 39 delinquent MLAs seeking their disqualification under 2(1)(b). Then 7/7/2022, Uddhav Thackeray, in his capacity as president of Shiv Sena, wrote a letter to the Speaker objecting to the illegal recognition of Bharat Gogavle as the whip of the Shiv Sena and reiterated the decision of the Shiv Sena political party to recognize Sunil Prabhu as the whip of the SSLP. So, Malas, what's happening here is, Malas, that the legislative party, a majority in the legislature of the Maharashtra Legislative Assembly, is treating itself as the political party and making orders for its own benefit. That's the constitutional issue that your lordships will have to decide.
But who represents the political party is
as I said, Malas, the two offices, Malas, that is the leader of the three offices, Chief Whip and Whip, are appointed by the political party and conveyed to the Speaker.
The Chief Whip
and the Deputy Whip.
The Deputy Whip.
So these are offices, Malas, that are bridge between the political party and the legislative
and then
party.
According to you, who determines who is the political party?
I'm sorry?
Who determines who is the political
There's no
party?
challenge here.
No, I mean, ultimately, who is entrusted with the authority to decide?
They have to have a split in the party first. Otherwise, how do you determine under the 10th schedule?
If there is a contest on who represents the political party, who will decide?
There's no contest, Malas. This is not their case. Malas, please appreciate. Till all this is happening, it is not their case that there is a political split in the political party. It is nobody's case.
No, but
They say they are the Shiv Sena.
Facts here, but who will then have the authority to decide who is the political party?
That's right. Now you go, what you do is call a meeting of the political party. Supposing, Malas, let's forget about the 10th schedule. Let's not talk of the 10th schedule. Malas, I happen to be a faction in the party, and I say, look, actually the majority of the party is with me. So I can requisition a meeting of the party. Forget the 10th schedule. And Malas, after a requisition of meeting of the party, Malas, I take over. So I am the party. By majority, I take over.
Against you.
And there's nothing to do with the 10th schedule. I'm not talking about the 10th. I'm sorry.
test as they have said.
Sorry?
The test in Sadiq Ali.
Test in Sadiq Ali is nothing to do with this issue, Malad. That's not, I'm not talking of the 10th schedule now. I'm talking generally how a faction in a party can take over the party. Forget the 10th schedule. Now let's forget that 1985 10th schedule was not there. Then also this question would arise. But this question would arise only if there is a division in the legislative party. Dehors the 10th schedule. I hope, Malaz, I made myself clear. Dehors the 10th schedule, this question can arise. That people in the legislative party can say that, look, no, we don't agree with your policies. Let's call a meeting of the party. Right? In that meeting, Malaz, they feel that they are a faction who are entitled, Malaz, to the symbol of the party. They want to set up a separate party. Right? They can go and say that we, the legislators, along with the organizational structure, are the party, separate party. Give us the symbol. We are the majority. Forget the 10th schedule. It can happen even out, but that can only happen if there's a split in the legislative party. Correct, Malaj? It can only happen then. Otherwise, it's a normal procedure of taking over the presidentship of the party. Sadiq Ali, the same thing happened. There was a split in the legislative party and the political party. And in Sadiq Ali, they said that, look, as far as the organizational structure is concerned, on both issues, they are entitled to, the other side is entitled to the symbol. That's fine, no issue. Here, mothers, this split should have happened on the 21st of June. There's nobody's case in the political party. Why? Because para 15 of the 10th schedule says that if there are two factions, and the symbols order says, if there are two factions resulting from a split in the political party, then the question of symbol will arise. Right, Malaj? It is nobody's case here. Nobody has, they say they are the Shivsena. Why? Because they are 40. So how does a majority on the legislative assembly become the Shivsena? Then, Malaj, if in the Congress in Goa, if majority of the Congress legislators join, as they do, Malaj, I've been seeing this happen again and again, Malaj, then they are the Congress. They can say they are the Congress. But how can they say that? Therefore, Malaj, this has grave consequences on the polity of this country. Because now the legislative party seems to believe that it can, under the 10th schedule, proclaim itself to be the political party and throw out office bearers who are appointed by the political party in the House. Constitutionally, that cannot be countenanced. Who appoints the leader of the House? Says, in exercise of my power as chairperson of the Congress Parliamentary Party, I hereby make the following appointment to the Rajya Sabha. Shri Kharge, MP leader of the Congress Party, against the vacancy of Ghulam Nabi Azad, whose term in the Rajya Sabha has come to an end on 15th February. This is a letter written by the Congress UPA chairperson to the Speaker, to the chairman of the Congress or the Rajya Sabha. That's how Malaz people are appointed. Can Malaj, Mr. Kharge on his own, or could he have said that I am the leader? I have so many MPs, so I am the leader? The same thing with the whip. Now, Malaj 57. The newly elected speaker, in an illegal, arbitrary, and blatant display of mala fide. And how do you, Malaj, allow this speaker to decide this matter when he's been doing these things? Your Lordship's Malaj has great, what should I say, confidence in the constitutional office of the speaker, Malaj. Great confidence. But do they discharge this confidence?
But that confidence you also have when you say that that speaker had to decide a disqualification petition.
Yes, correct,
And
mother.
that is not
It'll be
dependent
subject
on
to challenge. It's subject to challenge.
Right, and that is not dependent on who is the speaker, Mr. Sibbal.
No, Malaz, I'm sorry. That speaker did not do anything like this, Malaz. You have to now see, kindly see, look what is happening.
But the constitutional authority of the speaker to decide is not based on who the speaker is, on what decisions
Malaz,
he is taking.
can ever a finding of bias be reached by a constitutional court? You lordships will say no. Let's put it another constitutional issue. If a constitutional authority has so conducted itself that a constitutional court comes to the conclusion that such a constitutional authority cannot discharge the functions that it is discharging because of its open bias, your lordships will say no, we let them decide. I don't know, Malad. I don't have the answer for it.
No, not necessarily. In Rameshwar Prasad, with respect to a governor,
Governor,
the
yes.
judgment of this court that if there is an allegation of bias, then government has to come and defend it.
Malad, that's exactly.
It's possible, not that the court will naturally do it, but then we all are proceeding on the premise that, in fact, your argument had been in the first part also, that so far as the speaker is concerned, it's a constitutional authority.
No, but see what he has done. He has appointed the whip. He has appointed the leader of the house. What kind of confidence can we have in this constitutional authority? Who, without reference to the political party, is doing all this? Do you think he can ever decide in my favor? There is no way.
But then you have the first speaker who,
That's-
in defiance of the legislative rules, gives 2 days notice.
I'm sorry. No, that is.
In defiance of the
Malad,
legislative rules,
Malad,
gives
Malad,
2 days notice. What laws for the
that your lordship,
Yeah, all this is the way everybody is behaving.
and that's correct. So what do we do, Malad? Your lordships will then have to.
There are two options.
Asking some.
Either you debunk the authority of the speaker, or you say,
I said that
irrespective
on.
of what.
I said that on day one,
Or-
Malad.
or Alternately, irrespective of what lesser mortals decide, ultimately, in a democracy, you value the office or the institution.
Then that 27th
If
order
we
should
sta-
not.
If we say.
Correct. Then the
start-
27th order should not have been passed.
Denigrating constitutional officers, including the office of a speaker.
Malad, they are
then there's
denigrating
no end.
themselves.
It's a,
They are denigrating themselves. We are not denigrating
No,
anybody.
Mr. Sibbal, there's some problem.
it's a race to the bottom then.
Yes, we have. We have to start Mullad's. What to do, what to do. But the problem is, Mullad, that problem is very serious. And therefore,
It is they are the legislators, parliamentarians who have decided upon the speaker to be the tribunal for 10th schedule. It is parliamentarians' decision.
I agree.
Then
Mullad.
schedule. So therefore, court is only interpreting that.
Fine, Mullad. Then we must go back to
This doesn't
27th.
take us anywhere, Mr. Sibbal. The difficulty, repeatedly you say, at one stage, it poses a very big problem for the court.
Yes.
On the one hand, if the speaker is with you, you would say that it's a constitutional authority. What's wrong with the speaker? If you have some difficulty, you would say, you means not you. You would say, look at the way the speakers have behaved. So therefore, for us, as long as the Constitution bench judgment is there, we will go by the fact
I
that
agree.
the speaker is the tribunal and he is the presiding officer for 10th schedule.
Correct.
And
Correct,
we will
correct.
not go back the decision. That's the final decision so far as we are concerned.
Fine. That's, I mean, I don't,
Proceed.
I don't want to, Mullad, say anything contrary to that, except that on that logic, the 27th order could not have been passed.
You will argue that.
Then we come back to that. Mullad. Then that's what led to where we are today.
And again, it's merely because one or two speakers have gone astray. Would the court be inclined to debunk the whole procedure as laid down and the 10th schedule?
No,
by
no,
saying-
Mullad, I mean, my intention is not that. I'm just, Mullad, telling your lordships what has been happening.
So it's a conundrum.
Yes, it's a conundrum. It's a constitutional conundrum, but your lordships will one day have to sort it out.
Sorry for another question. Every time this question is raised before the court, I would want to ask you, how many times did the parliamentarians raise this question in the parliament saying that let us actually amend the constitution, change the speaker? How many times the discussion took place in the parliament to review the conduct of the speaker?
Mullad,
Why is that question raised before the court, which is not the forum for the consideration? How many times the parties have sat down together and decided that this is not working? Let us go back.
Once the Kyoto Holohan was rendered, Malats, what would Parliament would say?
Why it only upheld the 10th schedule. It is you making the 10th schedule.
No, Malats, the political party in power, wherever it is, wants to use the office of the speaker to do what they are doing. The political party would never, in power, would never like to change it.
This will take us nowhere, Mr. Sibal, frankly, and this will, unless there's an amendment to the constitution, unless there is a reference, a direct challenge, and so
Justice Sabharwal
we
said
have
it.
to proceed on that premise.
Justice Sabharwal said it in a judgment of this court, Jagdeep Singh. Exactly that. Undoubtedly, our constitutional scheme, the speaker enjoys a pivotal position. The position of the speaker is and has been held by people of outstanding ability and impartiality, without meaning any disrespect for any particular speaker in the country, but only going by some of the events of the recent past.
Constitutional entrustment of power.
Recent past. In the country, but only going by some of the events of the recent past.
Constitutional entrustment of power.
Certain questions have been raised about the confidence in the matter of impartiality on some issues having political overtones, which are decided by the Speaker in his capacity as a tribunal. It has been urged that if not checked, it may ultimately affect the high office of the Speaker. Our attention has been drawn to the recommendations made by the National Commission to review the working of the Constitution, recommending that the power to decide on the question as to disqualification on the ground of defection should vest in the Election Commission. I dread that as of today, Malats. Election Commission instead of the Speaker of the House. Concerned. Our attention has also been drawn to the views of a number of other experts, committees, commissioners, to the effect that power of disqualification as a result of defection needs to be exercised in accordance with the opinion of the Commission, as in the case of decision on questions as to disqualification of members. Whether to vest such power on the Speaker or Election Commission or other institution is not for us to decide, as your Lordship rightly said. Exactly. It is for Parliament to decide. Exactly. Right. I agree. I'm not disputing that. But I'm just saying the disquiet that we have witnessed in the functioning of the office, that's all that I'm saying. I'm not saying this person is good or that person is good. It's the institutional framework within which he functions, Mulad, is not consistent with his responsibilities as a tribunal. That's all that I'm saying. What to do? But the fact is that he had no authority in law to decide on the whip and on the leader of the House. That's not his.
That's a separate issue. We made it out of that.
That's why I make that argument. Then let's come to the newly elected Speaker, in an illegal, arbitrary, and a blatant display of mala fide and bias, issued notice to 14 MLAs seeking their response to disqualification petitions filed by Bharat Gogavle. The Speaker is still sitting tight on the disqualification petitions filed by Sunil Prabhu and has not even issued notice in them, despite their disqualification petitions being filed much earlier. He issues notice on their disqualification petition, but not on ours. And they haven't filed a reply, Malad. This court said in the interim, we adjourn it to 12th of July. Malad, from July, we are in February. Where's the reply? "18th of July, the notice issued by the Speaker in the disqualification petitions filed by Bharat Gogavle against 14 Shivsena MLAs, including Sunil Prabhu, was challenged by Sunil Prabhu in writ petition, wherein this Honorable Court, by order dated that, directed to tag the writ petition along with other connected matters." So that's also before your Lordships. And now, Malad, the Election Commission says they are the Shivsena. Now we'll be further disqualified. Any meeting called, if we don't attend, then when we are, Malad, then it'll be further problems. Despite the fact that this Honorable Court is seized of the issues regarding disqualification of Eknath Shinde under the 10th schedule, Shinde filed a petition before the Election Commission under para 15 of the election symbols reservation and allotment order to declare the splinter group led by him as the Shiv Sena. So this is the first time, Malas, that he went. On 20th July, by order dated 20th July, another in writ petition so-and-so, another connected petition, this court issued notice in writ petition so-and-so. It was directed by this Honorable Court, the writ petition shall be treated as the lead matter. 20th July, pursuant to the order of the court dated 20th July, Shri Subhash Desai made a representation to the ECI, by representation requesting ECI to not proceed with any petition related to Shivsena, as substantially similar matters and issues are pending before this Honorable Court, and not to take any preemptive action. Then IA 100285 was filed on 21st July, was preferred by Sunil Prabhu in writ petition seeking direction to the Speaker, Maharashtra Assembly, to produce the following records. All proceedings relating to disqualification of rebel Shivsena MLAs filed by Sunil Prabhu, all proceedings related to disqualification filed by Shri Gugavle, all proceedings of the Speaker and Deputy Speaker in relation to recognition of the Leader of the House and Chief Whip of Shivsena, proceedings of the House on 3rd July and 4th July. 22nd July, without deference to the proceedings pending before this court, as well as without considering that no adjudication can take place till disqualification petitions pending against delinquent MLAs are decided, Election Commission issued notice to Uddhav Thackeray on the petition filed by Eknath Shinde. And on 25th July, agreed by the issuance of the notice by the Election Commission, in Shinde's petition, Subhash Desai was filed 2 applications, IA so-and-so, seeking impleadment of Election Commission of India as Respondent 51 and writ petition so-and-so, and seeking stay of proceedings initiated by the Commission on 22/7 till the final adjudication of the present petition. On 4th of August, this court, after hearing the Election Commission and the parties, recorded the submission of the Commission that no orders may need to be passed by this court interdicting proceedings before the Election Commission. Liberty was granted to the petitioner to file an application before the Election Commission for seeking time. Accordingly, 6th August, petitioner in terms of the order of 4th August filed an application with a prayer to defer adjourn the proceedings in dispute on dispute number 1 of 2022 for 4 weeks and extend the time for filing a response for 4 weeks. 10th August, Election Commission communicated to the petitioner extending time. 23rd August, Honorable Court, by its order, held that the present batch of petitions raised important. Then those questions were, then Your Lordship, straight come to 23rd August, made a request on the very same day to the Commission to defer proceedings. Then this went on, Malats, and on 22nd of September, a further request was made by the petitioner to the Commission for deferment of proceedings by 2 weeks till this court decides the question as to whether proceedings before the Commission should go on, and then